subcontractors and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce the fabulous Jason Robinson.
Thank you, Jesse, much appreciated. Hey, I'm a construction attorney. I practice construction law day in and day out. That's all I do, construction law. And my focus at the firm, I'm at a firm that has 10 attorneys, each of whom practices construction law. We have guys with construction management degrees. We have an architect. We have a couple engineers. So that's what we do. And my practice is really focused on collection work, helping contractors, subcontractors, and suppliers to get paid. So Jesse, I really appreciate this opportunity to be here with you and the SunRay folks to talk about a topic that's near and dear to my heart, and that is all about my passion for helping folks to get paid. So quick disclaimer, just a reminder that lien and bond laws vary depending upon the state where you are working. We're going to be talking about Utah lien and bond law specifically today. And I would highly encourage you, if you're going to be performing work in other states, reach out to the SunRay folks, go to the website and learn about that state's lien and bond laws before you commence work, because oftentimes there are notice requirements, preliminary notices that preserve your right to pursue mechanics lien claims and payment bond claims and other claims. So let's jump right into this. We're going to be talking today about what mechanics liens are, why they're important, how to preserve your lien rights, how to make a lien claim, and then we're going to transition into payment bond claims, how to make a payment bond claim and how that works. And then maybe we'll get into a little bit of Utah's Lien Recovery Fund and how that works as well. And finally, Jesse will touch on SunRay resources. So what is a mechanics lien, right? What's a mechanics lien? The legal definition would be an involuntary encumbrance against title to real property, right? That sounds very, very legal, and it is. Let me explain it this way. If you or I were to go out and purchase a home, if you're like me, you would be going to a bank first to obtain a loan. When you get that loan from the bank has you sign off on a mortgage with a promise to pay, and the bank wants security. The bank gets that security by recording a trust deed against title to our home. And we want that. We welcome the trust deed because we want the loan so that we can purchase the home and move in. Well, that is a voluntary encumbrance against title to real property. A mechanics lien is an involuntary encumbrance. And the fact is, if you are a contractor, subcontractor, or supplier who has provided services, labor, materials, or equipment for the improvement of real property, you have the right to file a mechanics lien to secure payment. And again, unlike a deed of trust, a mechanics lien is an involuntary encumbrance against title to real property, because the owner of the property obviously is not consenting or agreeing or inviting you to file a lien. You're filing that because you were unpaid, and you have the right to do so. So here's how a mechanics lien works in a nutshell. It's a very significant tool in your toolbox of construction collection tools. The mechanics lien would be right on top, along with payment bond claims. So a mechanics lien works this way. If you're a contractor, subcontractor, or supplier, you provide services, labor, materials, equipment for which you have not received payment, you actually have the right to record a mechanics lien against that property. The mechanics lien gets recorded in the county recorder's office within the requisite period of time, and after you filed your preliminary notice that we'll get into. But suffice it to say, this lien is now against the property, and if you are unpaid, you actually have the right to file a lawsuit to foreclose your mechanics lien against the real property. And the outcome is that an owner can actually be required to pay twice. So let me pose this question to you. We talked about being homeowners, and let's say that we're building a new home. And of course, as good homeowners, we pay our general contractor in full. Our general contractor dutifully pays its subcontractors in full. But unfortunately, a subcontractor fails to pay the concrete supplier for the concrete material. And now the concrete supplier files a lien against the home. And here we are being faced with the unfortunate situation of possibly paying twice, right? I mean, how many would say that that's fair for an owner to have to pay twice? I would dare say that no one thinks that's fair. But on the flip side, how many of you think that it's fair that a material supplier, a subcontractor, a contractor go unpaid? And that's the conundrum that these state legislatures deal with. Is it better that an owner pay twice or a contractor, subcontractor, supplier go unpaid? And what the legislature has done is said, okay, as between an owner and an unpaid contractor, subcontractor, supplier, we're going to hold the owner accountable. The owner has to pay twice because the owner, as a matter of public policy, holds the purse strings and can issue joint two-party checks, can get lien waivers, and do things to make certain that the money, that the water gets to the end of the row, if you will, that the money gets to the folks who are owed the money. So who can file a lien? In Utah, there are two different types of liens. There are pre-construction services liens and construction work liens. We're going to focus on construction work liens today. Again, as I mentioned earlier, when it comes to construction work, it really means pretty much everything. If you're furnishing labor, materials, equipment for a project, you typically are going to have lien rights in Utah for that work. Now, here is how you preserve your lien rights. First, you're required to file a preliminary notice. We're going to get into that. Then you perfect your mechanics lien by actually filing a mechanics lien within the time period for doing so. You're then required to send a copy of the lien to the owner. And as we'll learn, that's your ticket to being awarded your attorney fees and costs. And finally, you enforce your lien by filing a foreclosure action. So this, I see this all the time, and I'm so glad we're having this seminar. When it comes to preliminary notices, sometimes I'll see someone will file a lien, and I'll say, well, did you file a preliminary notice? And they'll respond, well, yes, I did. Well, could you send a copy of it to me? I certainly can. They'll send me an email, and it's a letter that they have sent to the owner or general contractor, or some other type of written notice that was mailed out. That's how it used to be in Utah years and years ago. But now Utah has what's known as the Utah State Construction Registry. The Utah State Construction Registry, commonly known as the SCR, is an online bulletin board operated by the state of Utah, where certain documents are filed, including preliminary notices. And keep in mind that a preliminary notice is all about communication. In fact, everything we're talking about today comes down to effective communication. The Utah legislature has said, hey, if we're going to require that an owner pay twice, we're going to require that contractors, subcontractors, suppliers communicate with the owner. Let the owner know that they are on the job site and that if they are not paid, they have the right to pursue mechanics lien claims. So this is just a quick diagram. You can see that from an owner's perspective, the owner knows who the general contractor is, of course, and the owner may even know who the first tier subcontractors are, but it's unlikely the owner is going to know who the second tier subcontractors and third tier subcontractors and suppliers are. And that's why it's so important that Utah has the SCR, the State Construction Registry, and that people file preliminary notices to put the owner on notice that they're out there performing work for which, if they're not paid, they could file a mechanics lien claim, or as we'll get to, a payment bond claim. So this is a screenshot of what the SCR looks like. If you were to type in on the internet, scr.utah.gov, it would take you to Utah's State Construction Registry, where you can set up an account and begin filing your own preliminary notices, which you should definitely do. Utah's State Construction Registry and the preliminary notice requirement applies to all projects in Utah, both public projects and private projects. And on the private side, it applies to both commercial and residential. Now, on the State Construction Registry, there are all kinds of notices that can be filed, but candidly, a lot of these aren't really relevant to our conversation today, other than notices of, the key would be notices of commencement and preliminary notices. And that's where we're going to focus our time today. Okay, so we're going to begin with private projects. So on every Utah private project, be it commercial or residential, everyone. So in some states, you are exempted from the preliminary notice requirement if you're a general contractor because you're in privity of contract with the owner. That's not the case in Utah. Everyone, general contractor, subcontractor, supplier, everyone files a preliminary notice on the state construction registry. Your deadline to file is 20 days from your first date of work. So within 20 days of your first date of work, you need to file your preliminary notice on Utah State Construction Registry. Now, if you find that you have missed that deadline, you can file a valid late preliminary notice for construction work. But that preliminary notice would not go into effect until 5 days after the notice is filed. So for example, if you were, well, let's look at it this way. If you file your preliminary notice on day 20, it reaches back to day 1, and you're covered from day 1 moving forward through the course of the project. But if you file on day 21, you can still file, but your preliminary notice does not go into effect if you file on day 21. It doesn't go into effect until day 26, and you're covered from that point moving forward. So make certain to get that preliminary notice filed within 20 days of your first date of work. So preliminary notice, you're going to file this online on the state construction registry. You're just going to fill in the blanks, and the blanks are going to require this information. Since it's pretty self-explanatory, we're not going to get into that. You'll need a tax parcel number for the property where you're performing your work. Where do you find the information for your preliminary notice? You can look at other documents filed on the state construction registry, but I would advise you against relying on that information. I would say do your own homework, because two wrongs don't make a right, if you will. You want to make sure that your document is filed the right way. So we talked about preliminary notices. The other important document filed on the state construction registry is notices of completion. A notice of completion can be filed upon final completion of the original contract. That's a defined term we'll talk about in just a moment. A notice of completion can be filed by the general contractor, owner, lender, surety, or title company. And the effect of a notice of completion is it shortens the time for filing preliminary notices from 20 days to 10 days. And it also shortens the time for filing a mechanics lien, as you'll see here in just a moment. Now, it begs the question, right? What constitutes final completion of the original contract? Well, in Utah, it's defined as the date a permanent certificate of occupancy is issued if required. If that's not required, then it's the date of final inspection by the local government entity over inspections. And if neither a permanent certificate of occupancy or final inspection is required, then it's the date when no substantial work remains to be completed. So it's the date of substantial completion of the work on the project. Or number 4, if the original contract is terminated, so if the owner terminates the general contractor, then it's the last date on which substantial work was performed under that contract. So that's the definition of final completion. And it's at final completion, again, when that notice of completion can be filed on the state construction registry. The contents for a notice of completion, again, these are filed online, and you'll fill in the blanks as part of that. Okay, so construction lien. Here's another key place to focus. So you're required to file your lien within 90 days after a notice of completion is filed on the SCR. Well, how do I know if a notice of completion has been filed? Well, when you file your preliminary notice, you input your email address, and ideally, a copy of the notice of completion is then sent to you via email when it gets filed on the SCR. But I would advise you against relying on that, because I've seen a number of instances where folks who filed preliminary notices, and I've had this same situation myself because I file a lot of preliminary notices, where you file that and you don't receive a copy of the notice of completion. So you don't know that the time frame for filing your mechanics lien has been decreased from 180 days, which you see there below, to 90 days. So I would say it's a good practice generally to calendar out 90 days to file your lien, right? So just assume that a notice of completion has been filed on the SCR and calendar out 90 days. But otherwise, if a notice of completion is not filed on the SCR, you're going to have 180 days from final completion. Remember, that's the definition we chatted about just a moment ago. 180 days from final completion to file your mechanics lien. And then you're required to send a copy of the lien to the owner via certified mail within 30 days after filing the lien. And if you fail to send a copy to the owner, that doesn't render your lien invalid or void, but it does mean that you cannot recover your attorney fees and costs. So sending a copy of the lien to the owner within 30 days is your ticket to attorney fees and costs if you're the prevailing party. And make certain to say that, the green card, of course. So here are the contents, things that are required to be included in your mechanics lien. Sometimes people mess up on a preliminary notice or a lien. There are small errors or inaccuracies. Utah follows the rule of substantial compliance. So if you do have some small errors, you're probably okay, but just keep in mind that for attorneys, gray is green, right? That's where we make our money, is in these gray areas, if you will. So make sure that your preliminary notice and lien are both as accurate as possible. It behooves you to do so to avoid disputes and maybe expensive litigation. Your lien will be filed in the county for the county where the property is situated. You can file an amended lien, but it needs to be filed within the time frame for filing your original lien. So finally, now we have our lien filed, and we are going to enforce the lien. You're required to file a lawsuit to foreclose your lien within 180 days from the date the mechanics lien was filed, and at the same time you file a lis pendens, which is Latin for action pending. And at this point, you'll have an attorney involved who will file the lawsuit and the lis pendens for you. So just a time frame here for when things are done for your own reference, maybe a desk reference, a little cheat sheet there. So lien priority. In a lot of states, mechanics liens relate back to the first visible work. That used to be the case in Utah, but now all liens in Utah relate back to the first filed preliminary notice. And of course, that's the preliminary notice filed on the SCR. So banks, interestingly enough, banks can actually come in, lenders can come in and purchase priority. So if you have a lender who is giving a construction loan to an owner, maybe midstream financing, that lender can actually purchase priority by coming to those folks who filed preliminary notices and getting them paid through the date the construction loan trust deed is recorded against the property. You can actually bond off liens, and I've had instances where a contractor, subcontractor, supplier comes to me and says, "Oh no, they bonded off my lien. What do we do?" And I say, that's good news, right? That's money in the bank, because when someone bonds off your lien, they actually put up a bond or put a cash deposit in a bank, and now instead of foreclosing on the property, we're going after that money that's in the bank. There is an abusive lien statute in Utah, so make sure that you don't intentionally overstate your lien. Once you're paid, make sure that you release your lien in a timely manner. Okay, so now let's talk about public projects for a moment. In the state of Utah, there are no lien rights when it comes to Utah public projects, but in lieu of a lien claim, you have a payment bond claim. And in fact, on all Utah public projects, regardless of contract price, the state or its political subdivision, like a school district or a city, county, town, they're required to get a bond, a payment bond, for the protection of unpaid subcontractors and suppliers like you. And you have that claim in lieu of a mechanics lien claim. But again, you are required to abide by the notice requirements, which we're going to talk about now. So at the outset of the project, the general contractor, lender, surety, title company can file a notice of commencement on the state construction registry. And that notice of commencement only applies to public projects, not private projects. The notice of commencement gets filed within 15 days after commencement of physical work. And that's what turns on the state construction registry for Utah public projects, right? So if you have a situation where if you're a subcontractor or supplier and a notice of commencement was not timely filed on the SCR, then you have no obligation to file a preliminary notice, right? As a subcontractor or supplier to preserve your payment bond claim rights. Now, I would recommend that you file a preliminary notice anyway, because there's always a chance that you just couldn't find the notice of commencement that you want to attach your preliminary notice to. And again, it's all about communication. I mean, in real estate, the mantra is location, location, location. In construction lien law, it's all about communication, communication, communication. And if you file a preliminary notice on the SCR, even where there's not a notice of commencement, there's a pretty decent chance that that communication may get you paid without having to go legal and go down the litigation path. So the information included in a notice of commencement. And again, to make a payment bond claim, you're required to file a preliminary notice on the state construction registry. It's the same preliminary notice that you would file for private projects. And everyone is required to file a preliminary notice on a public project, except for those who are in direct contract with the owner. That would be the general contractor. But keep in mind, the general contractor is never going to make a payment bond claim anyway, because it would be their own bond. When you file your preliminary notice, you should attach it to a notice of the general contractor's notice of commencement on the state construction registry. And there are some exceptions that you can read about. We won't get into those in our high-level overview today. So if you find yourself in a situation where you haven't received payment, you have the right to make a claim against the payment bond. And too oftentimes, people will come to me and say, "Oh, yeah, I made a claim by sending a letter." A claim is not sending a letter. To make a claim against the payment bond, you're actually required to file a lawsuit. And what you need to do is this: you've got to wait for at least 90 days from your last date of furnishing services, labor, materials, or equipment to make a claim against the bond. So you're going to wait 90 days, but you're going to file a lawsuit against the bond within 1 year of your last furnishing services, labor, material, or equipment. So you got to wait 90 days, but then you've got to file before 1 year from your last date of work on the project. Now, this is interesting. If the state or a political subdivision fails to obtain a payment bond in Utah, you actually have a claim against the owner, against the state for failing to obtain a payment bond, which is pretty crazy, right? But to preserve the claim, you're required to give written notice to the state or its political subdivision within 90 days of your last date of work. And that notice has got to be sent out via certified mail. And it needs to identify the person who performed the work, which would be you, the person for whom you performed the work, identify the project, identify the amount you're owed, just that identifying information in the notice. Oh, this is fascinating. Okay, so we just talked about public projects. Now we're going to switch back to private projects for a moment. In the state of Utah, a lot of people aren't aware of this, but where you have a private commercial project and the contract price between the owner and the general contractor exceeds $50,000, the owner is required to obtain from the general contractor a payment bond for the protection of the subcontractors and suppliers. Pretty cool. And that's a claim that a lot of attorneys who claim to be construction attorneys aren't familiar with, that there is a private payment bond claim in Utah. So to make a claim against the payment bond, you're required to file your preliminary notice, the same preliminary notice we've been talking about. You're required to wait, again, 90 days from your last date of work, and you're required to file your lawsuit against the payment bond within 1 year of your last date of work for the project. And again, keep in mind, you are required to file that preliminary notice on the SCR to preserve your payment bond claim and failure to obtain a payment bond claim. If the owner fails to obtain a bond, you have a claim against the owner for failing to obtain a payment bond. And you can recover your attorney fees here too. On a mechanics lien claim, a payment bond claim, a failure to obtain payment bond claim, you can receive an award of attorney fees as the prevailing party. But again, you got to make certain that you dot the I's and cross the T's and do it the right way. So again, even on a failure to obtain payment bond claim, you're required to file your lawsuit again, within 1 year. So this is for folks who do residential work. Utah has what's known as the Lien Recovery Fund, although it has effectively been dissolved, but it's going to remain in effect until the state runs out of money. In summary, it works this way. If a homeowner can show that they had a written contract with a licensed contractor and paid in full, and that this is their primary or secondary residence, the homeowner can apply to the state of Utah, to the Lien Recovery Fund, for what's known as a certificate of compliance. If the owner obtains a certificate of compliance from the Lien Recovery Fund, then the owner can send a copy of that to the lien claimant, who's required within 15 days to release their lien from the property. But then the lien claimant can, there is some red tape, but the lien claimant can apply to the Lien Recovery Fund for payment. And I have collected a lot of money for subcontractors and suppliers from the Lien Recovery Fund. But there are a lot of dates and deadlines to collect your money from the fund. Now, here's what I wanted to chat about last, and that is mechanics lien claims and payment bond claims are not exclusive remedies. You have a whole toolbox at your disposal. You have an arsenal. You have lots of arrows in your quiver, if you will, for collecting money. And so in addition to your mechanics lien claim, remember, you have a contract, have a written contract. Utah has no usury law. It's common for suppliers to charge 18, 24% interest. In Utah, you can recover your attorney fees if you have a written contract with an attorney fee provision in it, or a statute that provides for attorney fees. You can get personal guarantees. Utah has a Prompt Payment Act. Utah has a retainage statute. So you have a lot of tools at your disposal for collecting money. And my encouragement would be this. I'm sure that it's felt like drinking from a fire hose today because we've covered so much material in a relatively short period of time. What I'd like to have happen for you is, I want a red flag to go up, right? When you're performing work and you're not being paid, oh, that's right, I have a lien claim. I may have a bond claim. I may have a failure to obtain payment bond claim. I may have a contract claim, Prompt Payment Act, retainage claim. When those red flags go up, reach out to SunRay, go to the website, figure out what your rights are, and do what you need to do to get paid, because that's my passion, is helping you to get paid. That's my goal here today, and I appreciate your time and SunRay for putting this program together. Thank you, Jesse.
No, thank you so much, Jason. That was incredible. You're right. It was packed full of a lot of information, but you went over it and explained it, so I appreciate that. We do have a question that has come through. It says, in Utah, do I need to be a licensed contractor to have lien rights?
Great question. You can file a mechanics lien as an unlicensed contractor in the state of Utah. That being said, under Utah law, you cannot maintain an action to collect money owed for which a contractor license is required. And so, and there are exceptions, but I could easily see a situation where this person is in the state of Utah working as an unlicensed contractor. They don't get paid. They file a lien. The lien is good for 180 days, and they file, maybe they file a lawsuit to foreclose the lien. I could see the owner coming back and saying, well, hang on, you're not allowed to do that because under Utah law, unlicensed contractors can't file or maintain collection actions in Utah courts. Now, again, there are exceptions. In fact, there are 5 exceptions that we won't get into right now, but it would behoove you to get licensed, right? But do keep in mind, if you are unlicensed, you may have some remedies to collect money depending on the facts and circumstances.
Okay, wonderful. And then one other question has been put into the chat box here. It says, do I have to have a written contract to have
No,
my
you don't. In
liens?
fact, you can file a mechanics lien. You can make a payment bond claim. You would even have a breach of contract claim without a written contract. The problem with so oral contracts are just as binding typically as written contracts in the state of Utah. The problem you have is you run into this, he said, she said, or type dispute over what was the scope of work, what was the contract price, what was the deadline for completing the work. And I can tell you from my own experience as a construction law attorney in court that if you don't have a contract, oftentimes that weighs against you because the public, especially a jury, expects contractors, subcontractors, suppliers to have written contracts because they're professionals and experts in that area. And so really the burden kind of shifts to them in that regard. So I would certainly encourage everyone to have a good written contract and to get it signed.
Yes, it's always best to have that written contract, but it's good to know that there might be other ways for you to still continue to get your money that's owed to you. All right, that is all the
Absolutely.
questions that have been posed so far. If anyone does think of a question that wasn't addressed, please feel free to reach out and we will be sure to answer any questions for you as soon as possible. Can you go to the next slide for us, please? All right, who is ready to win a gift? We're testing your knowledge. If you can answer these questions correctly in the chat, we'll go ahead and send you guys over a little prize. So the first question is, when is the deadline to file a Utah preliminary notice? And then the other question is, pardon me, when is the deadline for a general contractor to file a notice of commencement in Utah for a state project? So take a look at that. If you feel like you know the answers to those, go ahead and chime in our chat and we'll go ahead and send you guys out a little gift. All right, can you go ahead and go to the next slide for us, please? All right, so here are some of the SunRay resources to help you guys stay organized, know your deadlines, and secure your lien rights. Go ahead and scan this QR code to access these incredible resources. You'll be able to access the deadline calculator, project information sheets, and one important thing, if you're working potentially in a neighboring state, each state has their own lien laws and deadlines, different types of documentations that are required. So if you look on the SunRay website, you can go to our the state lien laws by which state you guys are actually doing your work in, and it will kind of break it down for you if it's residential, if it's commercial, what your role in the project is, and it will tell you exactly what is needed and what the deadlines are. So check it out. Go ahead and go to the next slide for me, please. All right, we have a new service that SunRay is offering, SR Receivables. We're going to handle your collections for you guys. We're here to help get you guys paid. So go ahead and give us a call, send us an email to find out more, and we'll be happy to help you guys. Go ahead and go to the next slide for me, please. All right, our next webinar with Jason about Utah's lien law is going to be October 22nd. So go ahead and register for that for free. It's don't sign a release unless it says this one thing. Register at sunraynotice.com/education. Go ahead and we hope to see you guys there. Go ahead and go to the next slide for me, please. All right, here is a Google review. If you guys could go ahead and scan that, give us a little review, give us some feedback. We really appreciate any of the feedback you can give to us. It helps us improve for future webinars, as well as helps get the information out to more contractors and suppliers like yourselves. Next slide, please. And with that, that is all we have for you guys today. Thank you so much to everyone that attended. We hope to see you at our next webinar. Again, Jason, you really were incredible. I hope you all have a wonderful and beautiful sunny day. Thanks again, everyone.